Hi there. Today I am answering the question, who inherits from you if you don't have a will in Georgia? Now, those persons are called your heirs. Don't confuse heirs with beneficiaries. Beneficiaries are persons named under a will, if you have a valid will, that inherit from you. Heirs are the persons who would automatically inherit from you if you didn't have a will. Now, it's important to know the difference, even if you do have a will, because if and when your will is probated, your heirs still get notice and are involved in that proceeding and have an opportunity to object to your will, even if you didn't leave them anything. So pay attention as I am going through who your heirs may be in your particular situation, because those are the people who, regardless of what your will says, still also get notice of that proceeding and are involved. But mainly I wanted to make this video for the folks that don't have a will and are interested in knowing, hey, who would get my stuff if I were to pass? So there's lots of misconceptions around this. The biggest one is a lot of people assume, for whatever reason, that if they're married, their spouse automatically inherits everything from them. And that may or may not be the case. If you or your spouse, if your spouse is the one that has passed, has children, and you don't have a will, then it's spouse and children. So let me kind of go through the list. If you are married and you do not have children in Georgia, your spouse would inherit your probate assets. Probate assets are things that don't already have a beneficiary on it or don't have a joint owner with rights of survivorship. So these are just things that are just in your name and actually pass under your estate. If you're married, no kids, all those things would automatically be inherited by spouse, like, of course, after all of your funeral expenses and bills and all of that are paid. Then, if you do have children, though, in Georgia, if you have a spouse and children, it doesn't matter if they're estranged, it doesn't matter if you haven't talked to them in 30 years, they still inherit from you. So, spouse and children. Now, spouses get at least a minimum of a 1/3 share. So if there are more than 2 children, spouse would still inherit a third and the children would split the other 2/3. If there is only one child, then spouse would get 50% and that child would get 50%. If there is a spouse and 2 children, then spouse gets a third, the other 2 children split the other 2/3. So it would be a third, a third, a third in that case. So then what happens if you're not married and you don't have children? Oh, and before I move on, actually, this also includes minor children. So this isn't just children that are over the age of 18. So you could see a scenario where if you have a blended family and your spouse passes away and has a minor child, that you could end up owning property that was in your spouse's name with that minor child. You could also end up owning property with your stepchildren. But just keep that in mind as you're kind of thinking through all of this. So if there's no spouse and no children, if there are grandchildren, meaning there were children at some point and the children unfortunately passed before you, but you have grandchildren, then all of your descendants come first. So grandchildren, if not grandchildren, then great-grandchildren, so on and so forth. Then let's say there's no spouse, no children, no grandchildren, no other descendants of that line. Then we're going to go to parents. So it would be parents equally, so half to mother, half to father. And then if only one of them is living, then it would be 100% to that parent. And then you move on. If there are no parents living, then it goes to siblings. If you've had any siblings that have passed away and you have nieces and nephews through that deceased sibling, then that sibling share goes down the family tree to those nieces or nephews, so on and so forth. So that takes care of everybody. You go all the way through that line. So siblings, nieces, nephews, great nieces, nephews, all of that. If there are none of those, then you move on to grandparents' line. So you go to both sets of grandparents. And if grandparents are not living, then you go to aunts and uncles. If aunts and uncles aren't living, then you go to cousins, so on and so forth. Now, there's lots of rules about, well, what if you've had a aunt or uncle or a cousin or someone that's passed before you, or what if all of your aunts and uncles are deceased, then it all goes to cousins, stuff like that. So the further you get down the line, it gets a little bit more nuanced. There's also an exception. You would have to prove it in court for any parents who abandon children. So if you're looking at parents as being heirs, there's a way to kind of get around parents who've abandoned their children. But again, you got to prove it in court. So I say all of that to tell you there's lots of little nuances. Make sure you have an attorney who knows how to calculate who your heirs are, knows how to tell you who your heirs are. So even if you are doing your estate planning, that attorney can tell you, hey, here's who's going to be involved in your probate. Here are the people that get legal notice and an opportunity to object, but also help you make an educated decision about maybe you need to do a will because maybe that's not the person that you want to inherit from you. So again, as always, I hope you found this helpful. Thanks, guys. Bye.